Good morning, and may it please the court. My name is Bruce Miller, and myself, along with attorney Jim Sullivan, represent Maria and Mario Troncoso in this matter. This is primarily a case under 44-714 based upon failure to repair the gate latch. Since the court is looking at the record in that respect, I will point out that at the trial stage and in the Court of Appeals, the plaintiffs have carried the only burdens necessary to survive summary judgment in this matter. Number one, the burden to produce evidence that Mr. Tyner, the landlord, knew that the Thorntons were keeping dogs. The second burden that we carried was the burden to produce evidence that Mr. Tyner knew of the broken gate latch and that he failed to repair that. And number three, the burden to produce evidence from which jurors may conclude that the dogs escaped through the gate that would have otherwise been secured by the gate latch. So we've carried the burdens necessary to bring a 44-714 case to the jury. By the way, I think it might be helpful to the court to see just exactly what we're talking about here. The gate is, this picture was taken actually several years after possession was delivered, but the testimony from the witnesses in this case, Mr. Thornton and Mr. Tyners, they agreed it was pretty much in this condition, except that it had the latch on it when he took possession.
Well, Mr. Miller, let me instead of offering you another hypothetical, let me ask you to articulate to us what your proposed rule would be, because it would be helpful to understand where you think that the outermost bound of this rule would extend.
Well, I would say that the proper application 44-714 is that once the landlord becomes on notice of the danger, his duty to repair is triggered. If he fails to repair, then he is responsible if that dangerous condition then produces the injury as a result thereof. We're not arguing for 44-714 to be construed any differently than it's been construed since they enacted the statute in the late 1800s. It's been consistent throughout that time. And one of the arguments that Mr. Tyner's put forward is applying it in this way is going to somehow injure the rental market, but he's produced no evidence of that, and I think it's just not logical. There is an incentive. The statute exists to provide an incentive to landlords to keep their property in repair, not only for tenants but for third parties. Thank you.